that document also include an assignment of benefits, medical release?
Yes, page 2.
And are these the documents that you're referencing to that Mr. Lerma signed and agreed to when he sought out plaintiff for treatment for his minor child on February 15th of 2023?
Yes.
Now, have these documents been changed or modified in any way from the date or the time when Mr. Lerma signed these documents?
No.
And in the normal and ordinary course of plaintiff's business, does plaintiff store and maintain a copy of these records in its file for Mr. Lerma and all patients?
Yes.
And did plaintiff do that with this record?
Yes.
And to the best of your knowledge, information, and belief, is this document, is this consent for participation, and is this assignment of benefits and medical release a true and accurate copy of the documents, I should say, that Mr. Lerma actually signed on February 15th of 2023?
Yes.
Thank you. Your Honor, at this time, plaintiff would move to admit into evidence plaintiff's proposed exhibit number 1.
It's admitted.
Thank you. Now, Ms. Johnson, I'm going to ask you to refer in plaintiff's exhibit number 1 to the second page, the assignment of benefits and medical release. Do you see that?
Yes.
All right. And is there a provision in that assignment of benefits and medical release wherein Mr. Lerma acknowledged and agreed to pay all amounts that are not covered, partially covered, or denied by his insurer, as well as any deductibles and or co-payments?
Yes.
All right. And does his signature on that also indicate that he acknowledged it was his responsibility to notify Hope Network of any changes in his healthcare coverage immediately?
Yes.
All right. Thank you. Now, Ms. Johnson, does Hope Network as a provider accept Medicaid coverage and bill Medicaid as a form of insurance?
Yes.
All right. Now, I'm going to, again, you testified earlier that you had a chance to review all records and files that plaintiff maintains for the defendant prior to today's hearing, correct?
Yes.
All right. Now, at the time defendant presented to plaintiff to seek out services, did the defendant provide any insurance coverage information whatsoever, be it primary, secondary, or both?
Primary. Yes.
It was primary?
Yep.
All right. Did the defendant present any secondary medical insurance coverage information?
No.
Are there any notes, or is there any notation of any discussion that defendant had with your intake that defendant had secondary insurance and would provide any secondary insurance in the course or either after the services were rendered or at any point?
The opportunity was there. I guess I don't understand. So,
At the intake process, have you, strike that. You indicated earlier that you had an opportunity to review the entire file and record for the defendant prior to today's hearing. Is that correct?
Correct.
Right. Is there included in the file and records for the defendant's account with plaintiff any notation whatsoever that during the intake process that defendant would provide secondary Medicaid insurance information at a further point?
No.
And when a patient presents at intake, you indicated earlier that it's customary, standard, and usual in plaintiff's ordinary course of business to make a copy of or to retain a copy of the insurance card or information that's provided by the patient to you?
Correct.
All right. And did plaintiff do that in this instance when the defendant presented to plaintiff for services?
Yes.
And if I were to show you a copy of that card that the defendant presented the plaintiff at intake, would you recognize it?
Yes.
Is it also customary and standard for plaintiff to take a copy or request a copy of an individual's driver's license as well?
Yes.
All right. And are you familiar if plaintiff also did that as part of the intake process with Mr. Lama too?
Yes.
All right. And if I were to show you a copy of both the insurance card that you referenced to earlier and his driver's license, would you recognize both?
Yes.
All right. Your Honor, let the record reflect that I presented defendant with plaintiff's proposed exhibit number 2. May I approach the witness? Thank you. Ms. Johnson, do you recognize the document that I've just presented to you?
Yes.
What is that?
It says Blue Cross and Blue Shield insurance card and copy of the front of his driver's license.
And these are the copies that you referenced to earlier in your testimony that were taken from the defendant at the time of intake. Is that correct?
Correct.
All right. Now, the copies that you're reviewing are just the front of each of the defendant's primary health insurance information. Is that correct?
Correct.
There's not a copy of the back of the card, is there?
Yes, it should be.
Would you agree that this represents a copy of the front?
Oh, yes, that's
All right. And would you agree that what you're reviewing also represents just a front copy of the defendant's driver's license as well that was taken at the time of intake?
Yes.
All right. Just the frontal images of these 2 cards, have these copies of these images been stored and maintained by plaintiff in the ordinary course of its business?
Yes.
Have these documents, or excuse me, have copies of these cards been altered or changed in any way from the time that they were obtained from the defendant? Do they represent and are they a true and accurate copy, to the best of your knowledge, information, and belief, of the cards, the insurance card and his driver's license as presented when he sought out plaintiff for services?
Yes.
Your Honor, at this time, plaintiff would move to admit into evidence plaintiff's proposed exhibit number 2.
Do you have any objection to that exhibit, sir?
I do not.
It's admitted.
Thank you, Your Honor. Now, Ms. Johnson, I'm going to back you up to the assignment of benefits and medical release. That's plaintiff's exhibit number 1. Do you see that?
Yes.
All right. Does that assignment and benefits of medical release reflect only one source of insurance information that was obtained by plaintiff from defendant at intake?
Yes.
And what is it?
Blue Cross and Blue Shield.
And does that document also contain a reference to a policy number?
Yes.
And is that policy number consistent with the Blue Cross Blue Shield card in exhibit 2 that you identified earlier?
Yes.
All right. Now, is there any secondary medical insurance at all listed in this assignment of benefits and medical release?
No.
Does it reflect self-pay for any other self-pay
Yes.
following Blue Cross Blue Shield?
Yes.
And what does that mean?
It means that he has primary Blue Cross and Blue Shield, and he's going to pick up all the balances as self-paid.
All right. And again, this was presented to the defendant before he signed it on February 15th, 2023. Is that accurate?
Yes.
So he would have had an opportunity to have reviewed the content and the substance of this document, indicating that he only had one medical insurance coverage source before he signed it.
Yes.
All right. Now, is it accurate that plaintiff then did fully provide and render medical services to the defendant's minor child after the defendant presented for intake?
Yes.
Can you just briefly describe, not in great detail, but just briefly describe what medical services that were provided and rendered to the minor child?
There's an intake for autism evaluation.
Okay.
And then a treatment plan established.
And after the services, is it accurate the services occurred on or about February 15th of 2023?
Yes.
Now, after the services were provided by plaintiff to the minor child, did plaintiff then complete and file a claim with the defendant's primary health insurer, Blue Cross Blue Shield, for payment?
Yes.
And were there any payments made by the defendant's primary insurer to plaintiff?
Yes.
And in the normal and ordinary course of plaintiff's business, does plaintiff maintain and keep a ledger or record of, for each patient, of payments that are made to any balance or invoice or services?
Yes.
And did plaintiff do so in this instance for the defendant and his account with plaintiff?
Yes.
And is it typical and customary when plaintiff bills a patient's insurer that plaintiff will receive a copy of an explanation of benefit from a patient's insurer as to the disposition of the claim for payment?
Yes.
And did the defendant's insurer remit an explanation of benefit or explanations of benefits to plaintiff after plaintiff submitted the claim?
Yes.
And is it customary and usual for plaintiff to receive that and store it and maintain it in the ordinary and usual course of plaintiff's business for each patient?
Yes.
And did plaintiff do so for Mr. Lerma's account with plaintiff as well?
Yes.
And if I were to show you a copy of the explanations of benefits that plaintiff had received from defendant's insurer, would you recognize those documents?
Yes.
Your Honor, let the record reflect that I presented defendant with plaintiff's proposed exhibit number 3. May I approach the witness, Your Honor? Thank you. Ms. Johnson, do you recognize the document that I've just presented to you?
Yes.
What is it?
Explanation of benefits back from Blue Cross and Blue Shield to Hope Network for services rendered.
And specifically, are these the explanations of benefits regarding payments and or contractual adjustments that were made for the charges for medical services that were provided and rendered to the defendant's minor child on the date of service that's the subject matter of this action?
Yes.
All right. And could you briefly go through what amounts were paid by the defense primary insurer and what the remaining balance was owing for the charges rendered? You'll have to ask.
May I get my glasses? Thank you. Okay, fine. The first one is February 15th. Charges were applied to the deductible. There was a contractual adjustment of $236.39. Deductible was $421.61. Another charge for February 15th, 2023. This is a medical examination bill at $251. Deductible amount was $132.96 and a contractual adjustment of $118.04. Same day, another service. This is all of the intake. Charge was $421. Deductible amount of $348.21 and a contractual adjustment of $72.79.
And after plaintiff received these explanations of benefits, did plaintiff maintain, store, and keep these documents in plaintiff's, or excuse me, in defendant's files and records in the normal and ordinary course of plaintiff's business?
Yes,
And to the best of your knowledge, information, and belief, have these explanations of benefits been modified or changed in any way?
no,
Do you believe these to be a true and accurate copy of the documents the plaintiff had received from the defendant's health insurer the plaintiff has maintained in the ordinary and usual course of its business to date?
yes,
Your Honor, at this time, plaintiff would move to admit into evidence plaintiff's proposed exhibit number 3.
Do you have an objection to plaintiff's 3?
So this last page here, I don't know if I'm doing it straight or not, but just like a call log, there's calls that are missing out for this for sure.
I don't know what, you are objecting, saying, indicating that your belief is that it's not a complete,
This last
Record.
page, that's correct.
and that some things are missing.
Yes, the phone calls I made to them.
Your Honor, I presented defendant with the 3 EOBs, but there was an extra page attached that I'm not seeking to introduce into evidence. So I'll remove that. My apologies.
Okay.
Uh,
Would that change? Are you still objecting?
Objection.
Okay, the exhibit 3 is admitted.
Thank you. Now, Ms. Johnson, you testified earlier that at intake, the defendant never provided any secondary insurance information, Medicaid or otherwise, correct?
correct.
Now, in the normal and ordinary course of plaintiff's business, does plaintiff keep an accounting or system of contacts that patients have with plaintiff regarding their accounts or services in
Yes.
any type of computer or hard copy form?
Yes,
Okay. What type of system does plaintiff maintain to keep a record of or to store those contacts that it has with patients?
we keep a phone log for the calls that are made. And then we also keep a copy of all the statements that are sent out. And if there's any letters that are sent out, those are all kept in copy in the consumer record.
And as it relates to the notes that you keep, did plaintiff do so as well for the defendant's account with plaintiff?
Yes,
It did keep a record of any notes or communications?
yes,
And if I were to show you a copy of the notes, the account notes that plaintiff kept for the defendant's account with plaintiff, would you recognize that document?
yes.
Your Honor, let the record reflect that I presented defendant with plaintiff's proposed exhibit number 4. May I approach the witness?
Yeah.
Thank you. Ms. Johnson, do you recognize the document that I just presented to you?
Yes,
What is that document?
it's our chart notes of any calls that were made or any communications made.
And these are the chart notes that you referenced to earlier that plaintiff keeps in the ordinary and usual course of its business to log contacts and communications between patients and between patients and plaintiff?
Yes,
And is this specifically the entire account log as it relates to those contacts that were made or contacts or communications made between the plaintiff and defendant?
yes.
And what's the date range as set forth in these account notes?
March 17th, 2023 was the first entry. by our self-pay biller. And then the last one was 8/25/2025 by our billing manager requesting collection activity.
Now, are these client account notes report, is this a complete and accurate copy of all patient account notes that were maintained that have been maintained by plaintiff or defendant of communications?
Yes,
And is this a log or document that you keep, or a record that you keep in the ordinary and usual course of plaintiff's business?
yes,
And has this document reflecting notes of contacts or absence thereof been modified or changed in any way from the date when each entry was recorded?
yes. Wait, I'm sorry.
I'm going to ask the question again. Has this document been changed or modified in any way from the date when each entry was recorded?
No, sorry.
I have a question. Because my understanding from what she said her job position was is that she's a senior manager of revenue cycle. How would she know if a document's been changed?
She did testify earlier that as part of her job duties and responsibilities, that it is her role to store, access, maintain, and create records and handle correspondence regarding claims and billings.
I can recognize that, but this is a record of communications made, and they weren't made directly to her, correct, ma'am?
No,
Okay, so calls are made, they're inputted into a system?
yes.
Okay, and so, again, how does she know if this is accurate or if there's been changes?
Well, I certainly can ask additional questions.
Yeah, I don't know that she's qualified, and I was gonna ask that about some of these other documents, but they haven't been presented to me yet, just admitted.
Yeah.
I don't know that the person who is up here as a senior manager of revenue cycle is keeping up with notes in a system for all the people that are calling there. There's no possible way, because that's outside of her purview. If she was doing that, she wouldn't have time to be a senior manager of revenue. So
Well,
that's why I'm trying to understand, how would she be able to answer this question truthfully versus I don't know.
Well, to the extent that she has personal knowledge of the system and how it operates, and I can certainly ask her, but if she has personal knowledge of the system, and
Correct.
she could testify perhaps or proffer testimony that our system is set up that when an entry is made by an agent of plaintiff, that it's a permanent note and that it can't be modified or changed. If she has that understanding or personal knowledge of the system, certainly she could testify to that.
That's a different question than what you asked her.
It is.
And so to the extent that she can describe the system to that specificity and whether or not it has those capabilities, case in point, we have systems here where we can input notes. The senior manager of the clerk's office is not monitoring all of those notes, can't tell you about glitches or if things are always, she's not in a position to testify as to that. So that's why when you're asking her if this is an accurate reflection of all the notes and there's been no changes, I don't know that she can answer that, but she can likely answer the question that you just posed.
Thank you. Ms. Johnson, you heard the court's concern and question regarding this particular system the plaintiff has that logs communications in real time on any particular date. Can you explain to the court how that system works and if any particular entry on a specific date in real time is a permanent one and whether or not that can be changed or modified by any individual, and if so, who?
Once the note is in there, it's in there, it stays in our e-care system, it's a medical billing system. It can't be altered, that particular note can't be altered. You can put an entry in it saying, you know, something that you're correcting something from above or whatever, or the date of, but you can't change that particular record. This is a printout of exactly what is in our e-care billing system.
So if an entry is made on March 17th of 2023, and once the agent or user or individual writes a note in the system and completes that note and presses enter or clicks permanent, is it your testimony that that record is a permanent one that can't be changed by any individual who works with plaintiff?
Correct, yes.
And let me ask you this. Do you have familiarity with this system?
Yes,
How long have you been familiar with the system?
4.5 years.
Now, you testified earlier that this was a complete accounting of the notes that have been reported of contacts between defendant and plaintiff, correct?
Correct.
And you testified earlier that this hasn't been changed or modified in any way from how it's been saved and recorded and stored by plaintiff in its records. Is that accurate?
Yes,
And do you believe, based upon your knowledge with this system, based upon your personal knowledge, do you believe this to be a true and accurate copy and representation of the client account notes that plaintiff maintained and stored of contacts between plaintiff and defendant?
yes.
Your Honor, at this time, plaintiff would move to admit as plaintiff's proposed exhibit number 4.
The objection.
Yes, I object to that one.
Okay, what's the basis of the objection?
It's inaccurate and incomplete.
You dispute that it's complete?
Absolutely.
Okay. To the extent that you're gonna offer evidence to dispute that it's incomplete, you are able to do that when it's time for you to give your testimony, okay? Okay, for the purposes of your case in chief, we'll admit exhibit 4. I'm noting your objection.
Thank you, Your Honor. Now, Ms. Johnson, do these account notes reflect contacts that plaintiff made to the defendant in an attempt to collect the balance that was owing?
Yes,
Can you describe for the court all such communications and contacts that plaintiff made in an attempt to collect the balance owing in the amount of $877.78?
first one is our self-pay biller posted a payment to the account. And then we were working on 30-day letters. We sent statements out and we sent 30-day letters. And then the next entry is a 60-day letter requesting the balance to be paid. And then after that, it was sent to the service line and they agreed to do collection activity. And then in June of 2025, one of our finance representatives received a call and was requested to call Christopher back. And then we found emails. We tried to contact them that way. And then in August of 2025, the billing manager sent a letter saying that they would, if Christopher would be willing to pay $650 if that was acceptable, which is over 70%.
So is it accurate and correct that multiple invoices were sent after the services were rendered, according to this law?
Yes,
Is it also accurate and correct that a telephone call was made and a message was left to the defendant on June 24th, 2025 as well, according to this law?
yes,
All right. And did you testified earlier that emails were sent as well?
yes,
All right. And is it also accurate, this log reflects the email addresses for both the minor child's mother and the defendant that were provided in intake as well?
yes,
And those email addresses are consistent with the email addresses that were provided by the defendant and the mother of the minor child during intake?
yes.
All right. And finally, you would agree that this communication log does not reflect any one single telephone call, letter, email, or communication made by defendant to plaintiff regarding the balance that was owing. Is that correct?
Correct.
Thank you. Now, you testified earlier that multiple statements, invoices were sent to the defendant at his addresses that was provided in intake. Is that correct?
Yes.
And just to be clear, the address that the defendant provided at intake and the address where those statements were sent were 100 Bonnet Road in Lansing, Michigan, with a zip code of 48910. Is that correct?
Yes.
To the best of your knowledge, information, and belief, will any of those invoices returned to plaintiff as undeliverable or not sent?
No.
Is it plaintiff's position or straight back? After those invoices were sent to date, has defendant made any payment whatsoever that hasn't been recorded or logged in your records?
No.
Is it plaintiff's position that the unpaid balance of $877.78 is the amount due and owing to plaintiff for the services provided in rent?
Yes. Yes.
$877.78. Thank you, Your Honor. I have no further questions.
Thank you. So do you have any questions for this witness?
Actually, I do. Okay. We're familiar that Open Network takes Medicaid
Yes.
and that you guys are a state provider for autism services in Michigan.
Yes.
And are you also aware that under EPSDT coverage that you don't physically have to have a card with you upon intake? That just verbally has to be said.
You said under what?
EPSDT treatment.
Your Honor, I'm going to object on the basis that that calls for a legal conclusion, and the defendant, or excuse me, the witness is not an attorney, not an expert qualified to answer.
The question of whether or not EPSDT, which I don't know what that stands for, just a
The
little.
Medicaid for autism. The full
Okay,
word.
so you're asking this witness if she is aware of whether or not it's required to show a card.
Just, yes.
I don't think that calls for a legal conclusion if she is over billing. She can answer that question. If whether or not she knows.
We don't need a card. We just need the number.
Do you also aware that under that same coverage that all you have to do is verbally mention that you have a Medicaid case and that after that it should be sent to CMH for approval,
You have to provide the number.
which you guys can pull up because it's a digital system.
Objection, Your
So
Honor.
you-
That's a statement, not a question.
Well, actually, that was pretty good well worded for someone who's doing a cross-examination. Because all he had to do was say, "True, is that correct?" He can make a statement on it, and you know that. So is that correct, ma'am?
We can't search for Medicaid. We have to have the number.
Okay.
In order to search the Medicaid CHAMP system.
But you don't necessarily physically need the card, which they're claiming
I just need the
you never
number.
had.
I just need the number.
And then I have another question for you. Can I post the bench for this paper? Thank you.
That's,
This is the one I objected to.
which is the call log. Did he admit it? He admitted it though. I
That
believe.
is for.
It's people for, so
she
she
does
has a
have
copy.
Right,
Yeah.
okay. On date 6/24/25, could you read the first sentence right there for me, please?
Received request from PS in finance to return call the client's father, who is wanting documentation due to being sent to collection.
I have a question now, because it says received request from PS. I don't see any note that says there was a call to put that in. And you stated earlier that everything's recorded in the system. So,
I'm sorry, can you publish your exhibits, please? Because I don't have a copy of, so I don't know what's going on at this point.
She does have the exhibits, Your Honor. The
Well,
one-
she's a witness, so she's gotta have them, but you're supposed to have a copy to publish. No? If not, we can make a copy.
I do have copies for you.
Oh,
I apologize.
Like specifically this one, since he's talking about it, so I can follow and figure out what.
3, 2, 3.
Okay, thank you.
You're welcome.
Okay, you're on exhibit 4, sir.
yes, ma'am.
What was your question to her?
On the date 6/24/25, I had her read the beginning of that sentence because it says received request from PS.
Okay,
And so I'm just wondering if they received a request, which was for me, whether it was an email or phone call, where's the log for that? Which I don't see one.
This is the billing manager that put the comment in.
Yes, because I called them directly and they put the note in after the fact.
is that a
The,
question?
I'm sorry. I lost my thought. I was just curious to
You're
why,
wondering about a note that
everything-
you said is missing from the 24th?
yeah, because it seems like, because I called before that and what they did, I had asked them for
Okay,
emails.
okay.
And so I'm just
So-
wondering where that log was at, because I don't see it on here. I see your guys'
can I explain?
Yes,
This e-care system is for revenue management. We're the ones that bill out. The phone call came into finance, which they don't put notes into the system. They in turn sent the call to us and asked us to call back. Since it was in collections for a year and a half, the collection agency asked us not to contact the, or discuss the case. But the billing manager, A. Miles, who made the entry on June 24th, did return the phone call and left a message. And that's the rest of it. So this is not from the finance person. The note that's on here is from the billing manager, A. Miles.
I'm a little confused, so Ms. Johnson, if you can help me.
Sure.
You're saying this exhibit 4 is from finance, or are you saying the note that he's looking for is supposed to be from finance?
The note just states that that finance received a phone call,
Okay,
and that's who transferred the call to us or told us to call them.
got
So
it.
that's what we did.
Got it. So these notes here are, if finance receives a call, they have a different system? Okay, that they would keep notes in?
They would just transfer the call to us or send us a message to contact the, whoever is calling.
Okay, but does finance also have a system where they record when they receive calls, or is it just, they just triage it? where
They
it needs to
triage
go?
it to us,
Got
yes.
it. You can continue.
I guess the other thing I was looking at was the email on here is improper for the mother, and they have a proper one listed in their documents as the other exhibit you showed me.
Just questions for this witness.
Oh, I'm sorry. I guess I was a little confused because you said that every phone call that I would make to you guys was recorded with notes. Is that correct?
Revenue management, yes.
Then I don't feel like this was the note that was made for me. This is like an inner office note, I believe.
But she
Is that correct?
specifically said revenue management, so every call made for revenue management is what she's saying.
Okay, I'm saying. So I have one more question. If I was to call Hope Network in Lansing, they transfer me to Grand Rapids, correct, for financing?
A revenue management office is in Grand Rapids, correct?
Okay, and then that's in a different system than this is what you just stated. Is that correct?
No, finance is in revenue, it's in Grand Rapids also. It's just a completely different department.
So all
So
those
you got
notes should
routed to
show
a
here.
different
Is that correct?
Yeah, all of the revenue management calls log are on this document that we're looking at right now.
And is there anything in the system where somebody could answer the phone call and not put a note in there?
I suppose.
That's all I have for.
Anybody direct?
No,
Okay,
thank you.
thank you, Ms. Chauncey. You can be excused from the stand. Do you have any other witnesses?
No, Your Honor, plenty for us.
Okay, sir, you wanted to give testimony?
Yes, sir.
You can stay right where you are. I'm just gonna swear you in. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
And that's just because I don't know what paperwork you have.
It was just copies of the stuff I submitted.
Yep, in case you need to show it to the other party. So you can tell me what you want the court to consider as your defense to the outstanding balance.
I sent a packet to the court a couple of days ago and I overnighted it to your office on Wednesday. You should have received it yesterday.
There's something that was uploaded into my file.
On Wednesday. That's when I came in Wednesday.
I didn't know, it said something about a brief, so I didn't know what it was. Let me see.
I gave him a packet. I just had exhibits and answers to your stuff.
Your Honor, plaintiff has not received to date any documentation from defendant as proposed exhibits to be introduced.
There were
at trial.
exhibits uploaded in my file.
I came here Wednesday morning.
Electronically.
Plaintiff would ask when.
Wednesday morning. I overnighted it. We got it yesterday.
Yeah, but I think the unless the civil department did it for him, someone uploaded exhibits into my file system electronically on the 8th.
That's Wednesday morning.
It's 6 exhibits in there.
Your Honor, on the 8th, here we are on the 10th, and while I understand the defendant's in pro per, I really do. This court issued a pretrial order that required all exhibits to be exchanged during discovery. Uploading exhibits and providing the other party with exhibits 2 days before trial is neither fair nor reasonable. That constitutes unfair surprise, prejudice. Certainly, the defendant had every opportunity to introduce documentation prior to today's date, but he didn't respond to any plaintiff's request for production of documents.
To be honest, I'm looking at these documents, they're documents you already have. These are not new documents. They're documents he would have gotten from your client. And I recognize it would have been beneficial for you to get in them during discovery, but I never have pro se defendants. It's very rare, I shouldn't say never, that they turn over anything during discovery because they don't get it. Just is what it is. I have to look at the pre-trial. I normally put that they should be exchanged 1 week before trial, not during discovery, but exhibits have to be exchanged during discovery. Because during discovery, you don't know exactly everything you may want to bring forth. That's just what you're seeking from them. I usually do put 1 week before trial, which you still wouldn't have been within that time frame. I'm looking at the documents. I'm not seeing anything in some of these that says exhibits. I'm just seeing a summary. I don't know if he is just uploading summaries. That's what I'm seeing. One of these documents looks just like this. And it looks like he just highlighted it. You have copies of what you're.
Yes, the only thing.
Can you
outside of
show
you
him
guys
what
had
you
was-
have here? Because
I do.
I'm just looking at what's in here. I just saw it my first time myself.
The only thing
doing that.
outside of really what you sent me is.
It looks like maybe some
my Medicaid
billing.
card to your daughter. This shows that she had medical coverage through Medicaid during the time period. These were your papers that showed you didn't bill Medicaid. And then these are all my Medicaid claims from the last 2 years, which you guys are not a part of, and they're ongoing before and after.
Yeah, what was uploaded actually looks more like highlights and not, or a summary, not
I
actually.
I only highlighted the
Only a
four
couple
pages.
of them had attachments in there, which
And
there
then
was,
I had email attachment.
Yeah.
too, just showed you
I
that
see
to
some of
you
it,
guys.
Okay, Your Honor,
Oh, and I had you guys answered them.
Okay.
That's it. That's it.
okay, well, Your Honor, I'm going to object to the correspondence and communication.
I don't know what it is. He hasn't even admitted anything. He's just showing you what he has. I guess to the extent he gets to a point where he wants to admit it, we could talk about it, but I don't even know what it is or what correspondence it is you're talking about at this point, because he's given no testimony yet.
Understood. I suppose we can take each exhibit.
Yeah, and then as he gets ready to admit it, we'll go through it then at that time, and see where we are. Okay, so you took your daughter in for some treatment back on February 15th, 2023, correct?
Correct.
At Hope Network,
That's correct.
okay, in Lansing,
Yes.
okay, tell me what happened.
We went in for the evaluation. I did paperwork myself. I contacted them ahead of time. We got to the intake. I had the Blue Cross Blue Shield of Illinois through my employer, and Mother carries the Medicaid card. We got there and we said, hey, we didn't bring our Medicaid card. He said, not a problem. We can.
You said we did, you got there and said what?
That we didn't have the Medicaid card with us. And they said, it's not a problem. We can get into that. And then we went through the whole self-pay.
They said it's no problem, slow down because you're talking a little quickly.
Sorry.
They said it's no problem, what?
They said it's not a problem. We can get that added in. I don't remember
Oh,
the
okay,
exact wording. It was 2.5 years ago, but they told us it really wasn't an issue, that we can take care of that.
okay.
Your Honor, to the extent the defendant is testifying that he was told no problem by some individual at plaintiff, by plaintiff's employment, I would object on the grounds of that. Is that hearsay statement?
I would imagine you would object, but for the fact that you didn't bring the person he spoke to either, you brought someone who's custodian of records. She's never talked to him for a day in his life.
But she's not testifying to conversations that,
Agreed.
that other individuals
Well,
had with him.
she's here to assert that these conversations didn't happen.
And she's done so based upon business records.
She's done so that there's no record, there's no note in her system, which is not all the systems we find out later at Hope Network. Based off his question, that people could call and there's no notes, or someone calls the finance department, they either don't have a recording system or their system's different from whatever they're using in her department. And so to the extent that he's telling me why he did what he did, I'm taking it for the effect on the listener.
Understood, Your Honor.
So it is, the objection's overruled. You can continue.
So we continued on with the intake. Everything was okay. We left there. We went back to our regular doctor, kind of told her what happened. Because we had to get a referral from a regular doctor. And she kind of told
Okay,
us.
so this was all intake. You still had to go back to get a referral.
Yeah, after intake,
Okay.
because they made a plan and then you go back to your regular doctor. Our
Okay.
doctor's kind of the one that steered us in this direction.
So this billing or this bill comes from the intake process.
Correct.
Okay, let's fast forward to how you're taking care of the Medicaid, because all the going back to your daughter's doctor does not have anything to do with this.
Okay, so there was multiple phone calls made and they had told me that they would run the insurance and rebuild me. like I
When were
asked
these
them to.
phone calls made and who made them?
The first time I called them was after I got the first bill, I believe. This was
Okay.
in the fall time, which I
Okay.
told him a long time ago.
Okay, so let me stop you. You went on in February for this care. You notified or you stated to whoever did the intake that you didn't have a card for the Medicare or Medicaid. And you were told, you can't remember exactly the words, but that you could take care of it later. And the later of you taking care of it wasn't until after you got a bill?
No, I called them about 3 weeks later and we went over the insurance and they transferred me out. And then when I got
They called you,
no, I called them.
you called them,
They've never called me.
and you went over the insurance, meaning what?
We gave them the Medicaid information. And they
So
said
you're
they would-
saying 3 weeks after that, you called them and gave them Medicaid information?
Yep, we called,
Who did you, what number did you call? Who did you talk to?
we called the main branch in East Lansing. Off of Hagedorn Road.
So you're saying you called Hope Network in East Lansing
Yes, it's on Hagedorn.
and gave them your what information did you give them?
The Medicaid number on the card.
Okay, what prompted you to do that?
My old lady reminded me to call them.
Okay, and then what happened after that?
They said they would rerun it and rebill us, and then I didn't get anything or calls or emails or anything from them until the first bill came. I called them back. They transferred me to Grand Rapids to the finance area. They said they would rerun the information and they would bill me again. And I just never heard anything else from them. And then it wasn't until I was doing my credit checks in the springtime, I seen a bill on there and I didn't know what it was for. I started looking into it, and it was Hope Network. So I contacted them and asked them for a copy of the bill, and they sent me the information for the billing and still only showed the Blue Cross Blue Shield. So I called back and said, you guys didn't rerun the insurance. And then the court papers came like 2 weeks later.
Okay, what else did you want the court to consider?
Well, I brought this paper, it just shows the email communications, like the dates, it's just a lack of communication through emails,
Emails between whom?
us and Hope Network.
Oh, this purports to show when you emailed Hope Network?
It just shows when they were emailing me, like there's never any billing in here, it's for enrollments and just non-communicative stuff that do anything with billing, but they.
Oh, okay, so you were receiving some emails from Hope Network and you're showing me that you didn't get anything that had anything with the bill?
Correct.
Okay, then we don't need to see that. I'll take your word for it that they didn't email you about the bill.
That's what it was. The other thing I brought was my Medicaid claims, just to show there was no claim from Hope Network and that it was covered during that time period.
I believe that they didn't bill Medicaid for that. Now where you have to show me is, where your burden is to show evidence that you provided them with the Medicaid information.
And we only did that verbally over the phone and in person. That was it. So there's no physicality to it. Or email. There's no email chain for it either.
Anything else that you have that you want me to consider?
That was it. The rest is just copies of their stuff. Just kind of reviewing it.
I'm just looking at what you filed and I think it looks like one of the documents is maybe I don't know what this is.
I put their assignment of benefits because they kept saying that they were billing me as a courtesy, but on that release form, there's 3 spots that releases them to assign Medicaid benefits. So I highlighted all those for them.
That might be, I don't know if that exhibit, you put that as exhibit 2 or something?
2, yes. I have a copy of it here if you want to see it.
Well, you can show it to the plaintiff's counsel. We have it in the system if they can file it.
What the defendant, Your Honor, is showing me is assignment of benefits and medical release. It's already been admitted into.
That's what I said. I think it's stuff that you've already
evidence.
admitted and you just highlighted it.
Yes.
Okay, so what is it that you're purporting to highlight on this?
On this form, because they keep saying that it's a courtesy that they didn't have to bill Medicaid, but on this release form, I gave them authorization 3 spots to bill Medicaid.
Okay, I am 100% confident that they do have that it's not a courtesy billing for Medicaid, and I believe that they were aware too. I think their argument is not that. Well, they did previously argue that it was a courtesy because that was the reason why I didn't grant the motion. But I think today the issue is that you didn't. They're saying you didn't provide them with the account number and that the account number was needed. To which you're saying that you provided the account number. When you okay, I'm just looking at what you highlighted. So you believe that because this is in their language, that meant that you were giving them permission to bill Medicaid?
Yeah, that's what I took out when I read that. They made it sound like they didn't have to bill Medicaid, it was just a courtesy, so I highlighted it during the time. I felt like you hadn't signed this paper and I gave you authorization to bill Medicaid directly.
Well, it just says it's an assignment of Medicaid, Medicare, and or other insurance. So it's not, this is just an assignment of benefits in general.
The middle one says direct billing by Hope Network to Medicaid and Medicare.
Correct.
So I guess maybe
I don't think that they're disputing that they would do direct billing to Medicaid. I don't, that's not their argument, at least not at this time. Their argument is we never got the number. And you don't have any evidence of the dates of the phone calls that you made, who you spoke to. You're saying, well, you did say the first call was 3 weeks later. And you said that was prior to you getting the bill.
Yes, that was before we got the bill.
And you called a number in Lansing, or you said
Yes, that's at East Lansing.
Did they transfer you to somebody?
Not first time. Second time they transferred me to Grand Rapids when I got the second bill, second bill.
Okay, so before you got a bill, you called, no one transferred you.
Correct.
And then the second time, you saying that you got a call. But then it was transferred to Grand Rapids.
So they're billing.
To the billing.
And then the last time I called them was they transferred me to Grand Rapids also.
Oh, so you called them at least 3 times?
Yes.
Okay, and so I'm trying to see. I don't see any records of any notes in this e-cares that would have been consistent with a time frame that you're talking about. So is that why you asked the question about the potential of someone not putting a note in?
Correct.
Okay,
And
because
that's
it's
also
your,
why I objected to it.
because your belief is that you made a phone call and was transferred to Grand Rapids office after you got the first bill, which the first bill was received in March of 2023. Is that correct?
That sounds about right.
And then, so I have the call that you said that you made in 3 weeks after your lady prompted you to do so. Then there was another call, you said, after you got the bill, that was the time that you were transferred. And then they said they would rebill you.
Correct. So they didn't bill me any balance left over. And I never received anything, so I assumed it was taken care of until I saw my credit report in the springtime.
Okay, so did you make payments on this at all?
Never know. Just the Blue Cross Blue Shield made a payment.
Okay, I'm looking at the bill, it's the same. Okay, did you ever get rebilled?
No, never. Not even until today. I
What?
just, the 2 notices a long time ago, that was it. The one of those 30 and 60 or 30, 90-day notices, the only ones I've ever received from.
Well, that would be a bill. You got note and some invoices.
Yeah.
Okay,
That's when I called the
but I'm just saying that you say you made a phone call, you gave them this information, they told you at least twice you'd be rebilled.
Right.
Did you ever get a rebill?
Not after that, no.
Okay, why didn't you follow up?
That's where I messed up. I didn't follow. I just had assumed that the medication took care of it. So I didn't follow through exactly.
Anything else that you want me to consider?
Oh, no.
You said something about an email address?
Yes, on their client account notes report, the mother's email address is improper.
Oh, okay, but that's not your email address is proper. then.
Mine was okay.
Okay, and what about the number for you? That was proper?
Yes, that's correct.
Anything else you have?
Okay.
Have any questions for them? You can have a seat.
Mr. Lerma testified that at intake, you and the minor child's mother had a discussion with some agent plaintiff regarding your secondary Medicaid insurance information that your wife or that the child's mother maintained. Is that correct?
That's correct.
Is the minor child's mother your wife or?
No.
And what's the name of the individual, the minor child's mother that accompanied you there to intake?
Yeah.
Deanna?
Yes.
What's Deanna's last name?
Schumacher.
Schumacher, okay. Is there any reason why Ms. Schumacher didn't appear here today to verify the claims that you made regarding the intake process there?
No,
Initially
it's
back
home
on
sick.
February 15th, 2023.
She's at home. My daughter's sick today.
Now, you testified as well to the court that you made at least 3 telephone calls to plaintiff after the services were provided, right?
Correct.
Yet you would agree, not one single telephone call is logged in plaintiff's accounting regarding communications that it received from you.
Correct.
And you heard Ms. Johnson's testimony about the triage process and what occurs with the intake of calls when plaintiff receives said calls, correct?
Yes.
So what prompted you 3 weeks after intake on or about February 15, 2023, to just call plaintiff to provide the Medicaid
The mother
insurance
reminded me.
information? I'm sorry?
The mother reminded me to call them.
Yet Ms. Schumacher's not here to verify that issue.
That's correct.
Where did you make the call from?
Our cell phones, my phone, her phone, I'm not sure. One of our phones, mine's most likely.
Where were you when you made the call?
At home,
At your home, Ms.
Yes.
Schumacher's home?
same home.
Both you and Ms. Schumacher reside in the same home?
Yes.
And you don't recall the names of any individuals with whom you spoke on any of these 3 separate occasions when you called plaintiff, do you?
No, I didn't take notes of it.
Did you record any notes in a notepad or write down any recording that would document any of these 3 telephone contacts that
No,
you
I
made?
did not.
So this is all based upon, would it be fair to say, just your memory of what occurred back in the year of 2023.
Yes.
And yet your memory is vivid and you can recall that you made these calls,
I absolutely remember making calls. Remember the
And-
conversations. I remember being transferred and put on hold. I
but
remember all
yet
that.
you don't recall the names of these individuals.
No, that wasn't what I was calling.
So beyond your testimony here today, you have nothing, no documentation and nothing else to verify your testimony here today that you made these 3 calls.
That's correct.
You have no reason to believe, and plaintiff didn't tell you at intake that it wouldn't accept Medicaid information to bill, correct?
Can you repeat that? Sorry.
You have no reason to believe the plaintiff wouldn't take your Medicaid, minor child's mother's Medicaid information for billing at intake, right?
No, we knew they took Medicaid. We asked them.
There were no issues or problems when you had that discussion, you or the child's mother had that discussion with plaintiff at intake, right?
No, it wasn't.
So if you had provided the Medicaid information based upon your interaction at intake, you wouldn't expect there to be any issue with plaintiff billing Medicaid if they had that information.
That'd been correct. Yes.
Thank you, Mr. Lam. Thank you, Your Honor. I have no further questions.
Is there anything else, sir, that you want to?
No, I'm all
Sure.
set. No.
Okay, you can make your argument.
Thank you, Your Honor. Your Honor, it is plaintiff's position that it has proven by preponderance of the evidence that it is entitled to the account balance of $877.78 based upon its claims of breach of contract, account stated in unjust enrichment. If we examine what's been introduced into evidence, the court will see as follows. First, we have the actual contractual agreement that the defendant signed on February 15, 2023, wherein the defendant, in the assignment of benefits and medical release, agreed to pay all amounts that were not covered, partially covered or denied by his insurer, as well as any deductibles or co-payments. Clearly, the defendant reviewed and signed that document. And additionally, the defendant only provided and presented his primary insurance information at intake. There's no dispute of fact that no number was provided for his Medicaid secondary insurance information at intake. As we heard the defendant testify, there was a discussion with plaintiff that he had secondary Medicaid insurance information that would be provided at a further and later date. But if we look at Exhibit 1, clearly, that's what information he presented to plaintiff at the time of intake. Second, we heard Ms. Johnson testify that plaintiff, based upon the primary insurance information that defendant provided at intake, billed his primary insurer after services were provided and rendered to the minor child. We heard Ms. Johnson testify, and we also introduced into evidence Plaintiff's Exhibit 3 that documents that his primary insurer, Blue Cross Blue Shield of Michigan, was billed, and that it remitted some payments, and that there were some contractual adjustments which left the defendant with his co-deductible amounts. Additionally, also introduced into evidence in Plaintiff's Exhibit number 2 is exactly what the defendant presented at intake. A copy of his driver's license and a copy of his Blue Cross Blue Shield primary health insurance card. Nothing more. And that's confirmed by the defendant's testimony himself that no Medicaid insurance number was provided at intake. Additionally, we also heard Ms. Johnson testify as to her knowledge about the accounting system the plaintiff has in place to log communications and contacts. We heard Ms. Johnson testify that if a call comes into finance, that call is triaged to another department, which in turn then records a communication that it has with a patient. We heard Ms. Johnson testify specifically to the content of Plaintiff's Exhibit number 4, which is a log of all communications that defendant had with plaintiff or vice versa. And what is peculiar about Plaintiff's Exhibit number 4 that I would ask the court to consider the credibility of Mr. Lerma's testimony and Ms. Johnson's testimony is this. We heard Mr. Lerma testify that he made 3 calls to plaintiff. One approximately 3 weeks after intake, then another around the second time that he received the first bill, and then a third call. What is peculiar and odd, given Ms. Johnson's testimony, is that not one of those 3 calls, or all 3 of those calls, would be logged into the notes. The sheer number, 3 calls, would logically suggest that if, according to Ms. Johnson, if a person maybe just didn't log in a note, it's possible, but at least 1 or 2 of those 3 calls would be logged in. But we see rather in Exhibit 4 the absence of any single one of the 3 calls. The sheer number of calls would highly suggest, according to Ms. Johnson's testimony about the system and how plaintiff, in the ordinary and usual course of its business, how it conducts and records communications, it would seem logical one of those calls would be recorded. 1 or more of those calls, all 3 of those calls should be recorded, but at least the likelihood that 1 or more of those calls would be recorded in here is highly suggestive. But again, the absence of any calls in Plaintiff's Exhibit number 4, supported by Ms. Johnson's testimony, supports the fact that the defendant never called or contacted or wrote plaintiff or provided any Medicaid insurance information for plaintiff to bill his secondary insurer. We heard all testimony here today from Ms. Johnson that they accept Medicaid, that they would have billed Medicaid had defendant provided that information. We heard Ms. Johnson testify that no such information was provided. They billed the defendant's primary insurer. It paid a portion. There was contractual adjustment. The remaining amount owing, Your Honor, is the defendant's responsibility. It's the co-deductible amount. It is plaintiff's position, Your Honor, that it has proven not only by preponderance of the evidence with Ms. Johnson's testimony, but with the documentation that's been introduced, that the defendant is indeed liable to plaintiff for $877.78, that he breached his contractual agreement to pay, that there has been an account stated between the parties, and he would be unjustly enriched if he's not obligated to pay plaintiff for the services that were provided to render. Respectfully, plaintiff would request that the court find by preponderance of the evidence that it has met its burden and award plaintiff complaint damages totaling $877.78, as well as taxable court costs of $118.95 and a statutory trial attorney fee of $150. Thank you.
Make your argument, sir.
Just want to argue that under the Medicaid rules, the EPSDT for autism treatment, when it says that you only verbally have to mention that you have Medicaid to them, they're supposed to stop you there and refer you back to CMH to get pre-approval. Like the intake should.
Where are you getting this information?
I read it under guidelines.
You read it under which guidelines?
The Medicaid information.
Okay, can you repeat what it is?
It's EPSDT.
EPSDT,
It's the Medicaid autism, it's like the.
and this is for specifically for autism is what you're saying?
Medicaid autism.
Okay, continue.
In Your
I'm
Honor,
gonna let him, I don't want you to cut his train of thought. I'm gonna look it up myself. Because I never heard of it.
to the extent though that these guidelines have not been admitted into evidence at
If
trial.
it's law, he doesn't have to admit evidence of law. He's saying, he says, this is the guidelines. He doesn't have to admit.
He cited no law, no compiled law, no statute. He's just stated that.
If it's a regulatory law, if it's a policy, he doesn't have to provide that as an exhibit.
And I would agree, but my objection.
I don't even know what EPSTD stands for.
I don't either. And the defendant hasn't testified or provided any testimony that would support his claim, other than he read something and there it is.
Well, that's what he's doing right now. He's telling us what it is.
But the time to have done so properly would have been his testimony when he's presenting proofs. He's giving a closing.
This is not the first time I wrote it down earlier, and then he did mention it in his testimony. I just don't know what EPSTD guidelines are. You objected and said it calls, maybe it was when he was questioning her, he brought it up. And you said it calls for a legal conclusion when he brought that up. So that means I need to go and figure out what EPSTD is, because I'm not familiar.
But it's the defendant's responsibility to prove any defense. He's not raised any affirmative defense of this EP, whatever it is, as an affirmative defense when he filed his answer to the complaint. And to rely on any affirmative defense, as he's claiming to do here in his closing statement, is not permitted at this point because he hasn't filed any affirmative defenses. So I would have just object on the basis that he hasn't filed any affirmative defenses pursuant to MCR 2.111 F2 through 3, upon which he now seeks to rely in his closing statement.
Thank you. You can continue. So you said something about an EPSDT guideline. Are you saying that this applies specifically for people with Medicaid, or is it for people who are seeking autism treatment?
Medicaid autism evaluations. It stands for early and periodic screening, diagnosis, and treatment. It's a mandatory Medicaid benefit for children under 21.
Okay, so your understanding of some regulatory law or rule is that if a person seeking evaluation from or for autism that are on Medicaid, they only need to mention this?
Verbally mention it, and then they're supposed to contact CMH. Between the two parties, they're supposed to contact CMH. From what I read, I'm supposed to call them first, kind of knock on the door, and then I mention it to them. They're supposed to call them and make sure it's approved for Medicaid.
You're supposed to call who first and knock on the door?
They're supposed to. I'm supposed to call CMH to get the door open. That's how it was read. And then they call CMH on the backside to check for the approvals, because CMH has to approve the Medicaid bill. So they should have never even
Okay, so are you suggesting that you did those things I'm not understanding why you're bringing this up. Are you suggesting that you contacted CMH?
No, I
to
didn't know
get
anything
the-
about the policies during that time. I learned about it after the fact. when we
Okay.
invited to the next one, but the policy says that if you verbally mention it, that they have to stop doing what they're doing and make sure that you're approved by Medicaid for the program.
Okay, so what you're saying is you believe that they were supposed to, because you told them that you had Medicaid, that they were supposed to vouch or to call CMH. I don't know if they're supposed to call CMH or not. I believe, though, that my understanding is that they can look up whether or not you have Medicaid. I don't know why this entity couldn't look it up. My understanding is that they need certain information, they can look it up in a system. No, my understanding is that you can look up their number if they don't have it. That's my understanding.
We take our daughter to emergency services without it. They find it just fine multiple times.
That's my understanding is that they have a system that they could look it up in. She's saying Hope Network doesn't have that system.
We need to know that he has it. I didn't know that he had
Well, you weren't the person he spoke to. So that doesn't help. You weren't the person he spoke to. You were you're senior manager of this. So he wouldn't have spoken to you anyways. If he had a call and said, I want to speak to a manager, it's highly unlikely they would have put her on the phone. Continue.
No, that was basically it. I just wanted to push that issue. Everything else, I mean, I only brought this to court because I knew that I followed what I was supposed to do. I made the phone calls. They said they were gonna do certain things and it never happened. The first time we came in, you and I were on a telephone conference and I told you that and you said, no, I believe you, but that's not what it is. We don't have to build them. And that's kind of how this whole thing just kept going forward. I was like, well, I know I did what I was supposed to do. So to me, it was a principle thing on my own side. Just felt like I did what I was supposed to do. I'm not getting built for something that I did what I was supposed to do.
Thank you. So again, I've heard both parties' positions. The burden is on the plaintiff by a preponderance of the evidence. So this is not a trial of a criminal matter. This is really for your benefit, not his, because he's clear on the burden of proof. He doesn't have to tip the scale that much, like it's a criminal trial where you have to prove it beyond a reasonable doubt. You just gotta tip it where it's more likely than not that that's what happened. And that you failed to provide this information based off the testimony. I can appreciate that we had testimony from the senior management for revenue cycle. And she testified to being the keeper of the records. And that she testified to the order in which these records are kept. There are notes here in exhibit, plaintiff's exhibit 4, which are client account notes and reports. And these account notes are only from January 2022 to October 31st, 2025. These notes reflect communications through an eCares account. And that would have been first from March 17, 2023, all the way through August 25th, 2025. This exhibit, although it shows communications that would have happened or taken place or noted during that time frame, the court is clear. It doesn't show every communication that would have taken place. If you say you called Hope Network and you were transferred, that wouldn't be here. That was even brought out by her testimony. There's a note here where they show that they received a call from someone, but the people you're saying you're allegedly speaking to, this is not their documentation process. So all I have to rely on when it comes to whether or not there was ever calls made outside of this is testimony evidence, and you provided your testimony. There's nothing even to dispute. There's nothing here to say, no, there was no other calls, because you provided a witness that only can tell me about the record of these calls, but not anything that says, no, he never called any other time. There's nothing there. So you're not tipping the scale yet. We also have this consent for participation, which based off some statements he made, it sounds like he was, I don't know, maybe unclear of what he was signing. Either way, you and your wife, significant other, bring your child for care. Your testimony is that you tell the representative at intake that you have Medicare or Medicaid, that is correct. And that you're told that you could provide that information at another time. I don't know why that wasn't transferred here. It would not be, though, his responsibility to transfer it here if he said that he told them that I have Medicaid. I don't have a reason to believe that they wouldn't say they had Medicaid if they had it. But it still would not be his responsibility to put that here. You did authorize to be billed in this form. You now are telling me that since this date that you received this service and you told them or notified them that you had this Medicaid, but that you didn't have the card or the number, and that you were told you needed the number, which is consistent with what Ms. Johnson said. They're telling you need the number. And so 3 weeks approximately, you say later, you're prompted by your significant other, you need to give them the Medicaid number. You say you called before you got a bill and gave this number, but that you called the Lansing office, you were never transferred to anyone. You provided this information, is what you're saying, that you were told you would be rebilled. The next thing you notice or you testify is that there is another, there is a bill. You receive a bill, and that bill is not reflective of Medicaid, to which you say you call a second time. This time you must be still calling the Lansing office, but this time you say you're transferred to the office or in Grand Rapids, which you're not clear which office it was, but you're transferred to Grand Rapids. You again state you give this information and that you're told you'll be rebilled. You don't get another bill, and you assume that's because they billed it and it's taken care of. You say you do get some statements. And then there's a third time that you say you call. And again, provide some information. I don't know who you would have spoken to during these times, but I believe you called. I also believe that you told them from the beginning that you had Medicaid. This was an issue that from the first time, I think you've been pretty consistent with, well, I told them I had Medicaid from the beginning. They told me I could give them the number, and then they never rebuilt. The same consistent story he's brought me here today. And so now telling me that because he didn't speak to the right person, or that there was no note put into this special eCares account, that somehow falls back on him, I have a problem with, because it was up until today that the plaintiff continuously took the position that they didn't even have to bill Medicaid, that it was a courtesy billing. That was your absolute position up until today. And I believe that was the position you were taking, but you're faulty in that reasoning. It's not a courtesy billing. If they tell you they have Medicaid and they provide that information, then you have to bill the Medicaid. But because you took the position up until today that it was a courtesy and that it didn't have to be dealt with, I have to discredit whether or not you did in fact get this information that your client decided they just was going to treat it as a courtesy. Because that's the argument that you continuously made this entire time. It was a courtesy. It's not a courtesy. You're absolutely required, if the person has Medicaid, to bill the Medicaid. And then you can't even bill them for any extra after that. He provided another insurance, so it should have, we would hope, covered it all. But I don't know where his phone calls went when he called Lansing and they transferred him. But I know it probably wouldn't have went in the eCares account unless he was talking to her department. Everybody's not using eCares over there. There's nobody else here to dispute his testimony that he called and made these calls 3 times and provided this information that he told these people in the beginning. And I have evidence that he provided from the beginning that we had valid Medicaid for my child. Why would he withhold that information? Who wants to pay for medical that they're not responsible for? It doesn't even make logical sense. So I don't believe that you tipped the scale even enough. I think at bare minimum, we're even, which means I can't give you the relief you're granted, or you're seeking. So for that, your claim is denied.
I just want to clarify the one point.
Yes.
Our position in this case has been that after a year, if a patient provides no information, insurance billing information, within a year from the date of service, after a year, whether it's Medicaid or primary insurer, provider cannot and does not bill an insurer, be it a
Oh, I'm
primary.
clear on that. That wasn't the arguments that was made.
That was.
The argument that was made was that it was a courtesy billing and that we don't have to, that was the argument. I can tell you the date it was made the first time, because that was what you relied on, or whoever was in your stead back on February 2nd. That it's a courtesy billing to bill insurance. We don't have to bill insurance. That was the original argument.
February 2nd of 2025.
2026. Even this case wasn't filed in 2025. Not in February of 2025.
Well,
At this point, I made my ruling,
understood.
and so I got to move on because I have a whole nother trial to start. It's 4 o'clock.
Understood, Your Honor. Thank you.
Thank you.
Did Your Honor want to keep the exhibits that were
I
introduced?
do not. Those are all his.
Don't. or-
I do not want the exhibits. Thank you. This is Elum versus Jaleesa Ellis, 25-04687R. Yeah, please state your name, please.
Jaleesa Ellis.
Okay, so what's your name?
And,
Mr. Elum. Yeah. Okay, you're the plaintiff in this matter, Mr. Elum.
yes.
Okay, I think this originally started as a small. Okay, and you are suing for $6,500. You said that if the defendant fraudulently used your debit card info to
DoorDash.
spend on DoorDash after you broke up. You tried to speak with the defendant to pay back for charges. She said she would, but has not made an attempt to do so. Also stole a MacBook from the home. You stayed in after we, I don't know, I can't read that word of the, I paid for it after we, something of the, tell me what happened.
No problem. Should I start?
I'm sorry?
I'm sorry.
Yeah.
Okay. So we broke up and things were.
When did you break up?
We broke up in 2023.
Do you know when in 2023?
I would like to say around maybe April.
April of 2023. Okay. Were you living together?
We was.
Okay. And you broke up, and did you separate from living with each other at this time?
We did.
Okay. In April, around that same time, is when you stopped living with each other as well?
I believe so.
Okay. And then what happened?
So once we broke up, it wasn't like a terrible breakup, but we grew apart, which
Okay.
what it. I'm knowing that once the breakup took place and she was out of the house, things were gonna be a little bit harder.
So
Financially,
you were staying in the house that you both were living in?
correct. I
So
purchased
she
the house.
left?
Correct.
Okay, continue.
Once she moved, it was her and her daughter who moved as well. We were coexisting. We still had things connected. So, for example, we stayed in the house together. I paid the mortgage and she paid the utility bills. When she moved, the utility bills are still in her name.
Okay.
That she was previously paying. But I had since started to make those payments by sending her the payment for those, rather than cutting them off and have to restart. I just send her the payment and got them paid. Or I will log into an account and then start paying.
Okay.
She was having a hard time with food, buying groceries and things like that. She asked me for help. I assisted when I could.
What do you mean she asked you for help?
She asked me if I could help her get food for the house for her in store.
So is this a one-time thing? She said, hey, I need help with food, or tell me how it happened.
She called me, basically asked me, I need help with food. Don't have any food here. You know, could you help me with food? Get buying food? Yes. I was able to help her out.
Okay, how did you help her out?
I provided food. I got her food for the house.
Okay, you sent food over there, or
I
you took her
purchased food.
Okay.
Yeah, took her food. There was a few times where she called and stated that she would like to, she still had my card linked to her DoorDash account. This is without me even knowing. And she started to use that card for food without my permission.
When?
This started, so initially, I didn't know when it started because I wasn't looking at my bank statement. I was noticing that it was a little bit off, but it was $20, $30. So maybe I bought some gas, maybe I did some, I wasn't looking deeply into it at
Okay,
that time.
you must be rich. You don't even
So-
pay attention to $20, $30 missing.
So for me, I have a thing where if I look at my bank account and I know what's in it, I tend to spend. So
Okay.
I try to not, I just
So
know.
you don't look in your bank account?
Right, I try to not look into it. Everything's
Okay.
on auto.
Got it.
So, and she's aware of that. So she started to make these purchases. And once I became aware, I said, hey, why are you making purchases to a DoorDash? Well, I bought some food from me in Storm. I said, listen, if you use my card, I'm gonna need you to let me know. I need that money that you spent back. She said, okay, I'll pay you back. A few months later, she asked me, can I use your card to get DoorDash? For that particular moment, I told her yes. It continued to happen frequently. Now I'm paying attention. I told her to stop using my card completely. And to pay me back for the amount that was already paid. Because at this point, we were not on the best of terms. And I feel like this was done maliciously.
Maliciously?
Yes. In a manner where it was back to back to back to back to back DoorDash every day.
Oh, everyday DoorDash. Okay. So you're saying in the beginning it wasn't an everyday DoorDash thing?
No, it was periodically. That's what I'm
Okay.
saying. I didn't,
So you didn't notice?
right, I didn't really notice.
And then there was the one time you said she asked for permission to order the food.
Correct.
Did you give her a blanket permission to use my card?
Absolutely not.
Okay, you said you can order food today.
Correct.
Okay. Did she have to pay you back for that?
Not that particular.
Okay. But you had already told her that she was gonna have to pay you for the stuff that she used prior to.
Correct.
Okay. And so then fast forward after this time that you said you gave her permission to order food, then you notice that she's using it frequently, more frequently.
Correct.
Okay.
And at this point, I'm irritated about it. What is going on with these DoorDashes? I've already told you, I already talked about it. She said she was gonna stop. And she had stopped. From after that point, I started to look into a little bit more. No DoorDashes there, no DoorDashes, nothing coming up on my account. Then she started up again when a little bit later, because this lasted from 2023 to 2024. She stopped for a few months and then started back up. I brought it to her attention and I told her, you gotta pay me back, 'cause I'm looking at this and it's a lot of money that you done spent. She said that she would, she never did. There was things at the house that she wanted to pick up. She went there when I wasn't there and someone let her in.
Okay. So you've been broken up for how long when this happened?
At this point, it's been about a year. Roughly.
Okay, so a year after the breakup, you're saying she went to your home?
Mhm.
Is that a yes?
Yes.
You were not there? And someone let her into your home?
Yes. So at this time, I was working, trying to start a business, taking care of my grandma. So I was moving around a lot.
Okay,
So one of my relatives needed a place to stay, and I let him stay in my home.
okay, so a relative gave her access is what you're saying?
Correct.
And what did she take?
At that time, she said that she was there for a things in the basement for like Christmas or something like that.
Okay, so when she
Ornaments.
moved that she had left some things there?
No, she took a lot of the things that she owned.
Not a lot. Did she leave some things there?
Possibly,
Okay,
yes.
and what kind of things did she leave?
Christmas ornaments
Okay, and where were those ornaments?
in the basement.
Okay, so during this time where she's coming and gaining access, is this around the holidays?
No.
Oh, okay, continue.
So she said that she needed to grab these items, or she wanted these items,
She told you this or she told the relative?
the relative.
Okay,
And then when I asked her about, because my relative called me, said Jaleesa's here, I don't know if she's here. And I texted her, said, what you doing there? She said she needed stuff out of the basement. And that my cousin had let her in. She took way more than what she was supposed to when she got in there. She took pots, pans, Christmas ornaments, the furniture for the like patio furniture, the MacBook. There was a lot of random things just taken out of the house.
okay. And you're saying that these items belong to you?
Yes, technically everything belonged to me. I
Who's
purchased
that-
it all,
What does
but
that mean technically everything belongs to you?
so everything that was left in the house at the time that she moved out was purchased by me. The Christmas ornaments was purchased by me. The MacBook was purchased by me.
Was it a gift?
The MacBook, no,
Who was it purchased for?
it was purchased for the home. So she had a laptop that she was using, and we needed a new one just to use around the house. I purchased the MacBook for use around the house. She started to use it for her schoolwork. She was in school. She started to use it for her schoolwork, and I was okay with that. I didn't have a problem with that.
You purchased a MacBook when?
I purchased that MacBook probably a year before we split, so maybe 2022.
2022?
Right.
Around what month?
I believe it would be like, I would say August.
Okay, so, and she came to get it, or you're saying she took this MacBook in what part of 2023? Or was it 2024 when she came and got it? When did she confiscate it?
It was 2023, I believe, when she came and got that.
What month?
I want to say maybe August.
So like a year later?
So
No, she moved out April 2023 is what you're
Right.
saying. So you're saying she came back a couple months later?
correct.
Okay.
At the time when she came and grabbed the.
So the MacBook would have been about a year old at this point, is what you're saying?
Roughly.
So we'll say you're saying she took it about August 2023. Okay, continue.
And then from there, the different tactics started to take place as far as she's hearing that I'm talking to other people, and she's now being really, to say the least. So she's catching wind that I'm dating, and she's now upset. So the bills that were being paid by me, they're now cut off. So there's no heat in the house because it was still in her name. She cut it off.
Okay, cut the
Abruptly.
utilities off that was in her name, but that you say you were paying.
Correct. Not only did she cut the heat off, she cut the internet off abruptly. There was a timeshare that was left to me by her deceased grandfather that I've been paying for the entire time of the relationship. And after we split, I paid the timeshare costs, and it was $1,400. Even though we had split, I said, okay, we can split the cost, because before I was paying it entirely. Now that we've broken up, I said we can split the cost of the timeshare, and you can take half of the points, I'll take half the points. I purchased the timeshare, I paid for the condo, so like the association fees, and then she logged into it and changed the password and stole the points for that for the year. She still has it. And all of these came about after the fact. She finding out that I was dating other people, and I believe partially the reason being was because the person that she might have been dating or end up dating had an issue with her still having some type of connections with me.
Continue.
So I reached out to her. I told her, about the money that was spent, or the timeshare, the money that was spent on the DoorDash, just using my card in general. She declined that she wanted to pay for any of it. I told her, if I don't get a payment, like if you're not gonna pay, I'm having to go to court. And that's what she decided she wanted to do. That's why we're here now. The same thing with the timeshare. This was later on after the credit card, the debit card transactions. This was just another way for her to go about trying to basically take from me.
Do you have any evidence that you wanted to provide the court?
I got some text messages in here. I got some disputes that I disputed through my bank about the DoorDash receipts.
Okay, and what are the text messages about?
The text messages about, sorry. Just some of this is about the timeshare. Some of this is when she asked me if I was talking to a female, and then after that, she turned the internet off. This is when she entered the basement here. This is a request for DoorDash. So she used the card, and then after the fact, she asked me, well, she told me after the fact. This is a message there. She claimed that I gave her permission to feed her in storm. After all of this started to happen, as far as the cutting off the lights, before all of these things happened, she came over to the house, popped my tires, and then after that, she started doing this stuff.
How do you know she popped your tires?
She said it.
Oh, she told you?
Yeah, she popped the tires, and I was home. I was in the bathroom.
Okay. What is the evidence that you wanted to provide?
This is some of the dispute letters that I tried to dispute with my bank on here. And then as far as Storm, because the relationship between me and Storm,
Which is her child, correct?
yes, which
Okay.
was her child. We had a really strong connection, a really strong relationship. Looked like basically a father figure for her daughter. Since all of this has been taking place, it's took a turn for our relationship as well. This is one thing that I tried to avoid. That's why I was originally, more open to, being okay, just neutral, for the sake of Storm as well. After this thing started to take place, I still would speak to Storm, but as
How
far
old
as
is
like,
Storm?
She's 15 now.
Oh, okay.
and I've known her since she was 3.
So you all were together from the time Storm was 3?
Up until she was 12. Where it is. So I started to send Storm money directly, if she needed it. That way I didn't have to speak to her. Well, I can give you some of that. And I believe, like I said, some of this stemmed from a relationship that she got into after we split farther down the line. I feel like the gentleman she was speaking to didn't like the relationship as far as us having bills and things like that.
Well, yeah,
Right, which I would understand, no problem. And like I
the
said,
closeness that you believe that some of this was triggered, you're saying by
Correct.
her dating. How long after the breakup did she start dating someone?
I'm not 100% sure.
Okay, so how does it that you're connecting that to when the lights or the utilities were taken out of her name?
Basically because at that particular moment, she told me she was dating, she would reach out and just would have conversations. And she would tell me she was dating. I didn't know if it was serious, if it was something.
So you all were still friends?
Yeah,
At that
we was
time, you were
cordial.
cool. Okay,
Absolutely. And then I feel like once things, after everything kind of happened, she started to be, I don't know, weird, I guess. I don't know how to.
I don't know.
She started to be strange as far as cutting off the lights and cutting off the internet, popping the tires, all of these things.
Okay.
After I moved on,
But you said she told you she popped the tires?
I was there.
You saw her pop the tires?
No, I was in the bathroom,
Okay.
and I heard like a
Got it, but I'm asking you, how did you know it was her? You said she told you.
yes.
She tell you why she popped your tires?
Yes. She popped my tires because a coworker of hers seen me out with a friend in Myers, and one of her friends drove her to the house. And
Was this before or after she was dating a new guy?
I'm not 100%.
You don't remember when this
No,
happened?
yeah, I'm not
Okay.
100% sure.
You're not suing for the repair of the tires, though?
No,
Okay.
no, those are under warranty.
Okay, got it.
unfortunately.
Okay. Anything else?
Uh,
You can get his evidence, please.
and, uh,
Okay. Your turn.
Do I have to stand up now?
You don't, you
Okay.
didn't have to stand up. either.
Okay. I'm going to prove that Kendall accusing me of stealing and fraud is completely retaliatory. Kendall and I was together, like you said, from 2013 to 2023. During our relationship, I was primarily responsible for cooking the meals, and he would pay for food or buy groceries. On occasion, when I didn't feel like cooking, he gave me his card with permission to order DoorDash. In 2023, we began having problems, and we both felt like it was best for some time apart. I got an apartment on my own, and he stayed in the home. He and a couple of his cousins actually were the ones that moved all of my things, which included the MacBook, into my new apartment. For the 2 years that followed, we continued to have a sexual relationship, and he kept providing for me and doing things like buying groceries and letting me order food with his card. I have a screenshot. Should I wait till?
Nope, you have the evidence that supports this now, you can submit it now.
Okay.
That's easier for me, because then I can flow. So these text messages are gonna tell me what?
That I would ask to order food and he would say yeah, or I'll tell him I ordered food and he'd be like, okay, well, that's fine,
Okay,
on
so,
multiple different occasions.
so on this, and we're gonna call this defense exhibit, there were what numbers, right?
Their letter.
Letters A. And I'm gonna include all of yours, sir, because you just put them together as plaintiffs one. Okay, the number ending in 4496, that's your number or his?
that's fine.
Okay, and so what I'm seeing here is from you, April 28th. So just to backtrack, he said you all broke up around April 2023. You're calling it time apart, he's calling it a breakup, but same thing. That you separated from the home in April 2023, is what you're saying?
About April, yeah, and I moved out in May.
Okay, and so, hey, And response, huh? Can you order my Chick-fil-A on my card using that DoorDash thing you use? Wasn't that him asking you to order food
Yeah,
for
this
him?
instance, I got food too as well.
Okay. What do you want? Never mind, I know. Thanks, Paul Nicias. I don't know what that means. Um,
Your Honor, there's gonna be a lot of like spelling errors and.
I'm not worried, I'm not worried about that. I'm just trying to follow. This April 28th, I don't see where you asked to order food or that he agreed that you could use his card for food. Am I supposed to see that on the April 28th date?
Yes,
Okay, I don't see that. On April 28th, I see where you say, I'm assuming he's the blue, correct? Or you're the blue?
I'm the blue, yes,
And so he says, hey, you say, huh?
yes,
He says, can you order my Chick-fil-A on my card using that DoorDash thing you use?
yes.
You don't know how to use DoorDash?
I don't have DoorDash.
It's clear. And so she says, what do you want? And then you said, never mind, I know what you want. And then, I don't know, that sounds like it has nothing to do with this. I'm sorry,
I'm sorry.
was there supposed to be another message after this that goes to what you want?
No, I guess more so proof that I had permission, like he knew his card was on my DoorDash.
Got
and I was
it,
ordering
got
food
it.
for-
So if there was a DoorDash used on the 28th, it wasn't because of you, for you, it was you ordering food for him, is what you're saying?
Yes, ma'am.
Okay, I see, May 5th, you don't DoorDash Popeyes yesterday? Probably he was asking, did you DoorDash Popeyes yesterday?
Yes,
You said no, day before. Oh, just posted yesterday. How's work? Okay. May 26th, can I use your card to order lunch? Was that you asking him?
yes.
Okay, this is, I think, May 26th. I don't see a response. Then there's a sir.
That's supposed to be sure.
Is it?
What I took.
Oh, okay. You're saying his response was to be sure. Got it.
Yes.
Okay, okay, that has nothing to do with DoorDash. This looks like it's all the way in July now. July. I mean, we're getting good morning, Texas. Have a good day at work. Can I order lunch and you pay? That's you asking him.
Yes, ma'am.
I don't see a response at all. And then a couple days go by. It looks like maybe the next day, actually, not a couple days, next day. It's meet at Kroger's. Looks like you all did you meet at Kroger's?
Yes,
Did he buy you food then?
yes, ma'am.
Okay, you're responsive. It looks like an hour after that. Thanks again. I really appreciate you doing this. His response, you know, I got you, girl. Let's see here. This is, now we're in February, months have gone by. I see where you said I'm ordering food too, so I'm assuming, I don't know why you're saying I'm ordering food too. Were you ordering food for him? I don't know what the two means. Or maybe you were just saying in addition to what you've already shared. I was just calling to tell you I seen you on the highway. And then you say I'm ordering food too.
Yeah,
Okay. His response, what? You said food, I'm hungry. He said, okay. Little flirts going on here. Some more flirts. Let's see here. Can I order food? And it looks like he didn't respond. You said, I did it. Let me know if you're mad. Is that correct?
that is correct.
He says, I'm not. I'm driving. You say, okay, be safe. It's not looking very broke up here. I'm gonna be very clear. Let's see. I don't know what this means. You finally bought the S. Dot Carter's. Okay, $21 DoorDash today. Thank you. I love you. It was for me in storms until I go to the grocery store later after work. His response, miss you too. Let's see. There's a question here. I don't know what this is. It's something about, it says possible fraud, page 1. I don't know. But that's a note that you wrote here.
Yeah,
Is that reference to him asking you about a $53 DoorDash?
yeah.
And you said, no, it wasn't me. You said, I haven't. You said, wasn't me. I haven't DoorDash since I asked you last time. Let's see, another one, possible fraud. Okay, that's the same $53, okay. Does someone else have your card? I'm about to order, but I'm using my card. You told him to report it because it wasn't you.
Yes.
Okay, you can continue.
When I left the home, instead of removing the utilities, internet, and trash from my name, he wanted to keep them there since I had all the passwords to the bill payment accounts and did all of the online banking stuff. And it would have been easier and more convenient for him to just send me the money monthly, and I take care of it as I've been doing. From 2023 to 2025, we continued our on again, off again dealings with each other. I mentioned to him a few times that I wanted the bills out of my name, but it would always end with him threatening me. So I backed down. And I have a screenshot as well of that.
Okay, this is going to be defendant B. Okay, Granger. Before next Thursday to transfer services into your name. Oh, call Granger. Excuse me, to transfer service into your name, or they will be removing the cards. And he says, oh, you want to play? Oh, that's how you want to play. You can come pick Baloo up, where he's going to the shelter. Is that a dog or a cat? Okay. Did he have your pet?
Yeah, we kept the dog at his house. I
Okay.
mean, with him because I couldn't have it at my
Okay,
apartment.
because you're in your apartment, okay. You can come pick Baloo up, or he's going to the shelter. I'm selling the house. And don't piss me off, Jaleesa. I won't end well for you, I promise. He says that twice, the second time with the emoji with the steam coming out of the nose. You can continue.
It wasn't until May 2025 when I became firm in my boundaries and wouldn't allow him access to me anymore that his language started to change. He started demanding that I return things to him that he had gave me. For instance, my living room couch and a couple of bar stools. I gave them back to him because, again, I wanted no problems. And I have a screenshot of him requesting the thing back.
I'm just following the timing. So this is May 29th, but like, what year is this? Because all the other ones have a year. It looks like the last one you sent me or gave me was in February 2024. That's when you're talking about Granger.
Yeah.
But this says just May 29th. So was this last May?
Yeah, I think
It's
like
like May
iPhone,
2025
it
or-
doesn't say like the year because it was just last year.
Okay. All right. So let's see. Morning, once the utilities are paid to zero, I will be taking them out of my name. That's you speaking?
Yes, ma'am.
Okay. His response, that's fine. You might as well go ahead and give me everything back to and have Bro replace everything. That way you can really, with a fresh start, you're able to now, but keep the same energy with everything. Jaleesa, good morning. You said it's not about a man, Kendall. However, if you want to come and get the couch and these bar chairs, that's fine. I don't want to make a big deal about this because it's really not that deep. That was on May 29th. It doesn't look like there was any communication until June 2nd. Do you want this ring back or no? Are we talking about a Ring camera or a Ring
No,
for
it
your
was
phone?
a ring he purchased me while we were together. Since he was asking for everything back, I asked him if he wanted his ring back as well.
Got it, okay. It's her turn. You have to wait till it's your turn again.
Now couchless, I started getting rid of old furniture in preparation of the new furniture that I ordered. I sent Kendall a picture of a table I was gonna throw out if he didn't want it. In the picture, my MacBook was present on the table. Instead of him saying something like, hey, that's my MacBook, you stole that, or what are you doing with that? He jokingly made a comment about if it was coming as a 2-for-1 deal with the table. And I have that text message as well. I'm sorry, Your Honor.
You're not, what are you sorry for? It's the case that's making my eyes do that. Okay, this is the MacBook in question, June 8th. Come get these chairs. Are these the chairs that we were referencing the other?
Yeah,
Okay. Your response or his response, the MacBook come with it. Your response, nah. Got it. Okay, keep going.
in June, I informed him that if he did not get the utilities switched out of my name that day, that I will be shutting the service off. This is when he accused me of stealing from him and initially said he was taking me to court. And I have a screenshot of that as well.
Thank you. Okay. I don't know what happened before here. Okay. I need you to call and get it switched out of my name today, both Consumers and Board of Water and Life, or I have to cut the service off. Okay, I need you to pay for the money you stole or I'm taking you to court. Your response, okay, call them today. Bet. Okay, then on June 27th, hey, send me the info to Comcast so I can change over. Okay, continue.
A month later, when he still hadn't done what I asked, and in an effort to move on and cut all ties with him, I had the service suspended and removed from my name. It was at this time that I also changed the password to my family's timeshare account, no longer giving him access. This angered him, and he stated that if he couldn't pick up the laptop from me that day, that he was going to report it stolen. In conclusion, I did not, nor did I have any reason to steal from him. He did for me freely on his own accord. If I wanted something from Kendall, all I had to do was ask. I believe that if I had never removed the bills from my name and allowed him in my space still, we wouldn't be here before you today. And then I have the last screenshot of the big blow up that we had.
Okay, so tell me about this MacBook. How was it purchased?
He purchased it while we were together, sometime during the relationship for school. I needed a new computer for my nursing school, and he came home one day with the MacBook.
And said what?
I bought this for you. I mean, he would regularly do things like that, like the ring that I mentioned before. He got that for me for Valentine's Day. He liked to dote on me, and then like,
Nice things.
yeah,
They got you a MacBook. You said you were in school
yeah,
and he said, I got it for you.
yeah,
So when you moved out in April, you took it with you?
yes.
Okay, so you say you didn't take it when you went back to go some decorations?
No, it was taken with all my things when I first moved out,
Okay,
because it was mine.
and did he ever use the MacBook?
No,
Okay,
We had another computer, in our office that he would use when he would do schoolwork or real estate stuff.
okay. Okay, let's see. Tell me about this family timeshare, because he said your grandfather gave it to him.
There is no like written literature anywhere that said my granddad was giving it to both of us. While we were together, we both utilized it. We kind of like took it over unofficially. And while we were together, Kendall mostly paid like the maintenance costs. So my granddad said, since you guys are paying the maintenance cost, you guys can use the points. And that continued on throughout like our whole relationship. And then once we broke up, we decided he still wanted to be able to have access. So I said, okay, well, we can split the money for the maintenance cost and we can split the points as well. And that's how that went.
Okay, so whose name is the timeshare in?
It's in my grandfather's name.
Oh, still?
Yes.
Oh, well, that's easy. Okay. Anything else?
No, Your Honor.
Okay, let me read these last group of text messages that you said. This was the big blow up. It says, you still playing with the yawn. Who's that talking? Is that you texting him?
That's Kendall.
He texts you, you still playing. You said, nope, you're responsible for your last bill at 1217. Is that the address?
That was the address. Yes.
Okay, we go to court. This was in July, by the way, so it would have been last July. We go court about done playing with you for real. Now I want money for every year I paid on not playing. Let's do it. You trying to steal from me. I don't like that. I'm not gonna repeat that part, but okay, I haven't stolen anything. You live at 1217. It's your responsibility for the bill. Do whatever else you feel. It's cut off, I'm assuming that says you need. Oh yeah, to do Kindle. The last bill was $100. I paid $1,400 for that day. Timeshare, what the F are you talking about? I got something for you. No, it was 156. What are we talking about here? He said he paid $1,400 for the timeshare,
Yeah, that's what he was
Okay.
referencing.
and you said no, it was 156.
No, he, in the midst of,
He's talking about two different things.
yes.
So he
yes,
said the
started
last bill was
mentioning the
$100. You're
timeshare
saying
when
no,
we
it was
was talking about
156.
the utility bill.
Got it. You're not even addressing the timeshare at this point. Okay, I'm calling to report payments as fraud for timeshare. You'll be responsible for paying. So you're talking about doing fraud in the text message to report payments as fraud in writing. You'll be responsible for paying it 156 and 1,400 are not the same. Your response, I paid half for the timeshare, Kindle. Half of 1,400 is not 156, like I said, wired. You're not making any sense. I don't understand. That makes two of us. They charged you 156 for your last electricity bill. As far as the timeshare, I paid you half the money for it. You didn't pay the whole 1,400. We are officially done with each other now. If you still want to pursue me in court, so be it. I'll pay the $80 for your last consumer's bill, is what you say to him. He said, I pay timeshare every year. I have not any of the time that I paid for. Like I said, you're trying to steal. Okay, so let's see, we are together every year that you pay for when you break up with someone. You don't get to go back and recall all or take back all the money that you spent in the relationship. Don't matter. You can pay for the money spent on the timeshare. Laptop, I'll pick up or reporting it stolen today. You cannot bully me, Kendall, you say. You and I both know you bought that for me years ago for school. It was a gift. Bully you, I paid money for something you're telling I can't use, and you're using pay me money. I haven't used all my points that I paid for. Exactly weird. Letting you know I turn in the papers for small claims. I'm selling the house. Okay, that's the end of the conversation. Any other evidence from you, ma'am?
No, ma'am.
Okay, Mr. Kendall,
Yes.
what do you have?
Okay, so those messages are chopped up. A lot of them are.
Okay, you
Um,
have the full messages?
I have them in my phone. I didn't print them all. Uh, some of them. So the information that's being provided is just from one side. This is after the point of her popping my tires, her uh, coming to the house, taking the things, and then the timeshare. The timeshare was 1,400. I paid the 1,400. She was supposed to pay her half of the 1,400. She never paid it. Then she changed the password and kept the points to travel elsewhere with the points after I had already paid for it. That has to be paid each year before the first of the year.
What has to be paid each year?
The association fees.
Which is $1,400 every year? Okay.
Correct. And I
Okay, so you're paying $1,400 once a year, is what you're saying?
correct,
Okay, and so you're saying while you were all together, you paid the $1,400?
correct. And after we split,
Okay, you paid the association fee during that time, and what's the issue?
so I paid the $1,400 after we split as well. And then she changed the password to use the points. I never used the points.
Okay,
That's why I said she stole from me.
okay, I'm looking at the messages that you presented. You talk about her messages being chopped up.
Which one?
You're not giving me the full messages yourself. But nonetheless, some of your messages overlap with each other, so I get the gist of what's going on here. Do you have any other evidence that you want me to consider?
Yes, I like to play audio, and then I would also like to show you. I tried to print these off. They're the list of the DoorDash, so you can get a view of the extent of what it looks like.
Okay, what is the audio of?
It's basically her at around the time all of this started to take place, as far as her cutting off the electricity and the internet and all that stuff started to take place.
Okay,
It's right around the time she at the top of one of those papers, she asked me, are you talking to Archaea? From there, the internet is cut off, and then it's a triple effect.
let me go back here. I did see something to that effect. I didn't know I thought it was talking about Archaea.
Mhm.
Okay, you talking to Archaea.
Mhm.
That was on Tuesday, July 1st, and you
Correct.
never responded
Correct,
until you noticed your internet was off.
correct.
What's the problem?
So this, after she found out that I was dating,
Talking to Archaea.
right, she started to do all of these things, internet, everything's got off, all these different things.
Okay, but you told me on your original statement that she started doing this because she was talking to somebody. So it was because you were talking to somebody.
Both, actually.
Okay.
So initially, when she caught wind that I was speaking to somebody, she started this up and started doing these things. Once she got into a relationship where I feel like she maybe liked the guy, I'm not 100% sure, but he felt uneasy. I feel like.
How do you know that? You know who she was talking to?
No, I don't know.
He told you he felt uneasy?
No.
Okay, I don't want to hear about it then.
We spoke, and I'm understanding from her things that she's telling me that he's uncomfortable with the relationship, and I said, okay, that's fine. And then all of these things started to take place, but it was just to take place.
It got messy. I can see that.
Correct.
I'm ready to roll. Okay, you're suing, and let me pull up this just so I can be very clear, because you put $6,500. Pre-trial statement, which I think I handled myself. You said that it was $1,500 for a Mac, $2,800 in DoorDashes, and $2,200 for lost wages and fees from cancellation on card. What does that mean?
So eventually I had to get a whole new card. And once I got a whole new card, I had to, like I said, everything was set up on auto pay.
Yeah.
That's why initially I didn't want to cancel the card. I just actually stopped using it. So once I canceled the auto pay, there was bills that were due to be paid that weren't getting paid.
That's not her fault, that's your fault.
But I had to cancel the card due to her. So
Okay.
once I canceled that card, those bills stopped being paid, and then I had to go in and pay late fees.
Those bills stopped being paid because you didn't update the accounts with your new card. You can't make her responsible because you didn't do that. So for your claim for lost wages and fees from cancellation, there's no cause of action. You can't prove that she's responsible for that. The DoorDash, I reviewed her records of DoorDash. I even reviewed some of your text messages, and some of them are consistent, the same ones she provided, where she's asking to use DoorDash, and you all appear very much to be still intertwined in these text messages. Some of these text messages I wouldn't even repeat on the record because they were X-rated. You all were still engaging with each other financially and emotionally and physically. That's evidenced by the text messages that she provided. And so I have reason to believe her story versus the story you gave, which that you all separated to have some time apart, but you obviously didn't completely separate. There's good morning text messages and I love you, I miss you, mostly Storm. You are still causing her to believe that you're in a relationship, but that you are having some time apart. And then you have the dog. So you all are doing something, but living separately. I'm done. The other issue that I have is that there's countless, you said that she used your card without permission, but then I have all of these records. You said only one time you gave her permission to use your card. That was a lie, because I have messages here where she is constantly asking you, can I use your card? I'm hungry. Can I order food? You're like, yeah, absolutely. You know, I got you, boo. That's what you're saying in these messages in writing. The only one time that I have in text message, because you've not provided me anything to support your statement, she provided me text messages that showed that you text her about a $53 DoorDash, when she said, that ain't me, baby. She said in the text message, you might need to cancel this card. You might be reported because it looks like you're being defrauded. You need to cancel the card regardless. The first thing I thought of when you tell me because you see money, you spend it, you don't log into your bank account, is I was like, whoa, because I check my bank accounts every day to make sure I'm not being defrauded. So I'm thinking, how in the world does he know someone, you know how much fraud is going on out here? So this whole story that you had to pay $2,200 in fees because of cancellation of card, that's your responsibility to grow up and update your credit cards where your bills are coming out of. It also was your responsibility, if you want me to believe that you all were broken up, to take your utilities out of her name, because that's fraud. You can't have utilities in her name and she doesn't live there. She has her own place. And then when she provided text messages that she asked you to remove it, I don't care what the reason was that she asked you. I don't care if it's because she saw you in a Kia with our Kia. I don't care if it's because she's dating a guy and he's uncomfortable. She has every right to say, hey, can you get these utilities out of my name? And she's asking you multiple times. And if I'm going to believe any portions of your story, which if I'm being frank, I don't believe much of it, then that's because you discredited yourself with your testimony about things, and then she provides all this evidence to the contrary. But if I were to believe anything, you made it clear that she's having a hard time financially, and you're trying to be there for her, and you're helping her. So why in the world are you keeping something in her name? Why would you keep that weight over her? You want me to believe you're trying to be a father figure for her daughter, but you're going to keep a burden on her, but you all are not together and you're hanging out with Arkia and Nakia? It doesn't make any sense to me. So no, as it relates to the DoorDash, you haven't proven that she has stolen or used your card without your permission for DoorDash. To the contrary, she has proven that she's gotten your permission. And only one time there was a question about a DoorDash, and she made it clear it was not her. As to the $1,500 for the MacBook, it was the MacBook. I see the picture with the MacBook in it at her house. there was never any inquiry in any of these messages, and you all were talking every day for years after she moved out about a MacBook. I believe that you bought her the MacBook because she was in school. I believe her testimony when she says that you didn't even use the MacBook, and she asked you, based off of you threatening her to come and get other things, and you mentioned the laptop, she says, no, you're not getting the laptop back. She offering you the ring back. She's offering you things that you bought her as gifts. She is absolutely correct in saying that when you break up, you don't get to now try to take back everything that you gave as a gift in the relationship. You don't get to do that. That was part of you being the man in a relationship and being with your significant other and loving on her. And it sounds like even after you are separated homes, you all still were loving on each other in some capacity. I don't know where it went left. You actually in this do not mention timeshare fees, but the timeshare, your grandfather is deceased.
Yeah.
It's in his name. I can't order anything on a timeshare that's in somebody who's deceased name. That's a probate court issue. You don't have a claim to it unless probate court said he gave it to you. If he gave it to you, it has to be in a will. Do you have a will that said he gave it to you?
No.
Your claim is dismissed. Any additional matters for the record?
Yes, I just wanted to close this out.
Absolutely.
The amount of door dashes on here, it's in the hundreds of door dashes.
I don't dispute that, but where did you provide me evidence that you had, hey, where does this DoorDash come from?
That's what I was.
You didn't provide me no evidence where you told her she got to pay you back for it. There was never a single time where you said you got to pay me back for that. There was one time though where you were flirting and she asked you if she can get DoorDash and you took too long to respond. And by the time you responded, she said, oh, you're not going to put up a fuss. She was like, I already ordered it. You was like, okay, cool. You said not to put up a fuss. You said, nah, you're going to pay for that now, but you said it in a sexual term. So please don't come in here and try to think you're going to manipulate me without some evidence. You were supposed to bring some evidence to support it. And unfortunately for you, you weren't as savvy as she was when it comes to compiling the evidence. So you didn't bring anything to support your claim. She brought evidence to the contrary. And so judgment is 0. You're all set.
You said that that's the small, what was that for the timeshare?
Property or things that people can give as part of their death, unless they put it in a will, it has to go to probate. You can't come in here and say that he gave it to me and you don't have any proof. It has to be, it's a probate court issue. And if he is deceased, all of his property is supposed to go through probate court. And the probate court decides where and how it's going to go. Usually it gets separated to the family, not family's boyfriends, but I'm not a probate judge.
Okay.
You're all set.
Thank you.